Okay, we're ready?
Rolling.
All right. Good afternoon. My name's Ben Eliezer. I'm a criminal defense lawyer here in Toronto. I've been in practice for about just over 26 years, most of them spent before Her Majesty's criminal courts in Ontario, in provincial court, as well as Superior Court and the Court of Appeal. And like any criminal lawyer or defense lawyer who has any kind of exposure to that kind of work, I've done more than my fair share of domestic violence cases. And there are some things that go on in that system that are thoroughly unpleasant, and there are many things that are quite proper. The important thing, one of the important things, is to maintain perspective, to understand that there is usually more than one side or two or three or four to any particular set of allegations. I don't want to oversimplify the problem or the issue, but you look at a baseball, just a regular everyday baseball that you toss around or whatever. Yeah, it's a baseball, but it's made of leather and string and elastic inside, and it has a core. It's multi-layered. The same thing goes when it comes to the law. So one of the first things that it seems to me we need to bear in mind is that there are bad people out there. There are people who deserve to be charged, prosecuted, and thrown in jail, or saddled with a full criminal record because their conduct falls outside of what we deem acceptable in our society. On the other hand, the criminal justice system, particularly when it comes to domestic violence, is built on the premise that men are inherently evil and violent, and that women need to be protected against those traits. There is also the unstated principle, but it's clearly operational in the criminal justice system, that a woman would not lie about being assaulted in general or sexually assaulted in particular. So in the hypothetical situation where a call comes into 911 asking for police assistance because of an incident at a home, the officers are dispatched to respond, and the first thing that they do is they run the address and the name through their database to determine if there have been any previous attendances at that residence. The police arrive at our hypothetical house and they observe the following. There are two children in the home somewhere. They may be crying, but everyone knows they're there. The husband is covered in bruises and a little bit of blood. The wife has a scratch on her neck, and the police ask what happened. The husband says, "She attacked me, look at me, and I fought back." The wife says, "He attacked me, and I did everything I could to protect myself. And yeah, he's bruised for me, but I mean, I was afraid for my life, and I did what I thought I had to do." And she's crying and she's upset. The likeliest outcome of that scenario is that the man is going to get arrested. He's going to get put into handcuffs, thrown out of the house, kept away from the home through his bail conditions. He will have to reside with another adult, a surety, until such time as his matter is resolved. There is an inherent institutional bias against men in the criminal justice system. And just so that I'm clear about this, and in the interest of full disclosure, when I represent women charged with domestic violence, I take full advantage of that bias. And I try to get a sentence that is far lighter than any male accused could ever possibly hope to achieve. There is a bias, and I would not be doing my job, I would not be doing my duty if I didn't exploit those opportunities. When dealing with domestic violence allegations, the entire system, particularly when it comes to male accused, is designed to borderline extort a guilty plea. They will do anything and everything that they can think of to get the accused to take responsibility and to admit the truth of the allegations, even though they have no basis. They have no way of knowing what happened. Neither do I. I wasn't there. I don't know what happened. I know what my client tells me. And I know what the disclosure says. Yes, sometimes clients give me versions that make absolutely no sense in comparison to the incontrovertible physical evidence. I never touched her. Well, how do you explain that two of her teeth are missing and she has a black eye? Never touched her. Well, yeah, but no, she did it herself. She fell down the stairs. Okay, well, when you get that kind of position from a client and it happens, then you have to figure out what to do. But what you get a lot of is people who are charged because it's convenient. The most frequent scenario when that happens is the complainant, in the overwhelming majority of cases, the overwhelming majority of complainants are women. Men are embarrassed to call the police and to have their wives, girlfriends, relationship partners charged. I'm the man. What kind of man is going to let a woman assault him? It's ridiculous. I'm going to be embarrassed and this and that. But the statistics show, all reliable statistics show, that domestic violence is initiated in equal proportions by men and women. So, the overwhelming proportion of complainants are women. I'm not going to stand up here and tell you that the overwhelming proportion of allegations are false. They aren't. They're true. The system gets it right most of the time. The police are not stupid. They usually get the right person for the right reasons. A lot of criminal defense lawyers don't like to say that. What I do most of my time in court is try and raise a reasonable doubt. I don't have to prove my client's innocence. My client is presumed innocent. I have to raise a reasonable doubt as to the reliability of the evidence, which is a very different exercise. That's my function. The Crown has to prove my client's guilt beyond a reasonable doubt. However, there are lots of cases where the allegations are false. And as I said before, they are made for the purposes of convenience. For example, the couple the couple is living together. The marriage isn't going well, not at all. One of the partners wants the other one out of the house. If you're the woman and you're aware of how the system works and how the game is played, the easiest thing to do is call 911. Guy's going to be out of there in a heartbeat. That's just going to happen. So if you are inclined to make false allegations, if you have that kind of determined character, then you will succeed. There's a high likelihood that you will succeed. And he's gone. Now, you may want him out of there because you're carrying on with somebody else. You may want him out of there because you're soon going to serve him with divorce papers, and you don't want to go through the mess of a motion to get exclusive possession of the matrimonial home while he's still here. Let's say he's not living with you. You're living separate and apart. You've got the kids in the house. But he's fighting. He wants custody. He wants access. He wants to lower his support payments. Whatever. One of the greatest things you can do to stall is to accuse him of criminal acts. He'll get arrested. He'll get detained. And let him work it through the courts. I had a client who was arrested on 4 separate occasions on the eve of a court appearance. in his divorce. 4 separate occasions. Charged with harassment and breach of bail. I took the unusual step of having all of the matters tried together all at once in front of the same judge in provincial court. And when I was finished with the complainant, the judge basically said, I don't believe her. What she's saying is impossible. It's physically impossible. I didn't come out and say this in my submissions because that may have been crossing the line as far as my professional responsibilities as an officer of the court. But my basic position was she would have been better off accusing my client of having kidnapped her and thrown her into a spaceship and sent it off to Mars. That's how I presented that defense. And it worked because it was true. The fact that an accused wins his case or secures an acquittal from the court doesn't mean much. And here's why. In a lot of cases, what a judge will say is, I've heard the evidence. I don't know what happened here. The standard of proof in a criminal case is guilt beyond a reasonable doubt. The standard of proof in a civil case or a matrimonial case, a divorce, is the balance of probabilities. So if you're the plaintiff or the petitioner in a divorce, divorces are petitioners and respondents, regular lawsuits are plaintiffs and defendants. So if you are the petitioner/plaintiff, in order to win your case, all you have to do is establish a scenario that is more probable than the one presented by the other side. You just have to cause a ripple in the water. That's how they teach it in law school. You imagine a perfectly still lake. If you cause a ripple, you win. That's balance of probabilities. Beyond a reasonable doubt, of course, is a much higher standard. It's effectively a moral certainty. So what a judge will say is, I've listened to the complainant, and if this was a case where the standard was the balance of probabilities, I would find you guilty, sir. But it's not. The standard is guilt beyond a reasonable doubt. And so, I find you not guilty because I'm left in a reasonable doubt. And a lot of judges will say, I find you not guilty, but I do it reluctantly. That's what I operate with. That's the environment in which I make my living. So, the guy who's won his case, so to speak, comes out of there not vindicated, but basically made to feel like, you know what, I'm not sure what happened here, and you may have gotten away with one, but I have no choice. You know, I wish I could do something else, ma'am, but your husband I have a reasonable doubt. That's ridiculous. That's absurd. You're either guilty or you're not guilty. Not reluctantly not guilty. But the system has been designed so that people in it, the stakeholders, judges in particular, and crowns, are afraid to simply say, this complainant lied. They have no difficulty saying that about the accused, by the way. If the accused takes the stand and the judge concludes that that accused lied, there's no hesitation in making that absolutely clear. I completely disbelieve the accused. I reject his evidence. That doesn't happen with a complainant in a domestic violence case, particularly when the complainant is female. You simply don't hear that with nearly the frequency that you do when they talk about the accused, who is presumed innocent, by the way. So now he's won his case. Well, that's not the end of it. The allegations keep going. Because now we're into the matrimonial courts, where, as I said before, it's balance of probabilities, best interests of the child. I have a friend who used to do matrimonial work, and the amount of time that he spent fending off allegations of the sexual abuse of children and spouses at the hands of the father or slash husband was staggering. Staggering. And the one thing courts don't want is, well, we don't believe her, so we're going to give the husband what he wants, and the next day somebody turns up dead. Or you're insensitive to the plight of women. Not in this society. You can't do that. The institutions that we've built up over time have made everyone afraid to do that, have made them afraid of speaking truth to power. Some people would ascribe all of that to institutional feminism or institutionalized feminism, or what I've heard called and have in fact called feminazism, which is a complete intolerance of men. There have been law professors who have expressed, in Canada by the way, the notion that men should not be allowed into law school. Think about that. There are legal clinics for people who have no money who will not represent men charged with domestic violence. Why?
Are they government funded?
They are funded by the school. I don't know where the money then comes from, but the school decides how the money is allocated. But Osgoode Hall simply wouldn't represent men at one point. I don't know what the status is now. There was a hue and cry. And it's absurd. I'm sorry? Yeah. So, what happens next? If the name of the game or the object of the game after an acquittal is for the man to clear his name, he should forget it. It's not going to happen. When somebody gets charged with a sexual assault, it's on the front page of the Star and the Sun and the Mop and Pail or whatever. When he gets acquitted, it's at page A18 underneath the ad for a special on Javex bleach. Good luck finding it. When you read articles about criminal prosecutions, take a look over time, not in any particular article, but over time, how many times the Crown is identified by name, but not the defense lawyer. Because nobody wants to dignify the defense lawyer. I'm the scum of the earth. Why? Because I represent the scum of the earth. My guy isn't the scum of the earth. My guy is an accused who is presumed innocent. And if he's convicted, he should be sentenced according to law. The legal system is supposed to rise above our instincts. That's why it exists. It's so that we don't beat up on each other when we don't like what someone has done. It's so that we don't torch the other person's house or murder his family. It steps in with a set of rules and principles for dispute resolution. That's what it's about. And it functions on reason, logic, evidence, and principles. Not the so-called victim theory of criminal law. I appear on a radio show every week, and I have more than once said that for the purposes of the criminal law, there is absolutely nothing special about women, and I mean nothing. She's a witness. That's all she is to me. I don't care about her in any other respect. Why? Because if I start to care about her, I stop to do my job. And my client is counting on me to protect his rights. That's what this is about. As a human being, do I care that she may have been assaulted or sexually assaulted? Of course I do. I'm a human being. I would never do that to another person. It's not the way I was brought up. And my client may well be guilty. But to me, it's not a morality play. We have a legal system that stands between us and our worst instincts. Once a man is charged with domestic violence in general, and sexual domestic violence in particular, he's finished. He's done. Especially if he is a teacher or works in the so-called vulnerable sectors. Maybe he gave the student a C minus, and she wanted a B plus because she's trying to get into God knows what school or wants that new car. So all of a sudden, he touched her inappropriately. The guy's finished. Absent a videotape of the incident, he's finished. I had a client charged. It wasn't a domestic, but it's illustrative, if you'll permit me a bit of a digression. Got charged with a sexual assault. And it made no sense. None. I read the disclosure, I read the transcripts, I read everything. In preparing for this trial, it didn't make any sense. I'm cross-examining her, and I said, and she came out, when the Crown was examining her in chief, so the first round, she said something that I'd never heard before. And I cross-examine her, and I say, now this thing here, yes, you remember saying that about half an hour ago? Yes. And it's true? Yes. You didn't say that to the police, did you? Nope. You didn't say it when you were in court on this a few months ago, did you? Nope. You haven't said it to anybody, have you? Not before today, and this thing was a couple of years old by that point. And she says, yes, I did. I said, really, who'd you say it to? And she points at the Crown Attorney. That's the kind of moment it takes to win those cases. A greedy witness. Otherwise, my guy goes away probably for 3 to 4.5 years. It's a non-domestic. 3 to 4.5 years.
That's in 7 or 8 years.
Oh, yeah. I had a domestic sexual assault where the allegation was that my client had had intercourse with his niece almost every week, twice a week. She would have been 16 at the time. He was in his 40s. In the condo that he shared with his wife and his sister-in-law. The complainant was the daughter of another sister and had decided to charge my client because he had told her, we're moving to the U.S., we're not going to sponsor you to stay in Canada anymore. Bang, sexual assault, she gets to stay in Canada, or so she thought until I beat her into the ground. I haven't even told you the most interesting part, or what I thought was interesting. All these sexual assaults were alleged to have taken place in a 700 square foot condo. The police bought it lock, stock, and barrel. No, not a shred of evidence other than her word.
So hearsay.
It's not hearsay. Hearsay is when you relate what somebody else told you. It's all circumstantial evidence. So, for example, in 30 seconds or fewer, direct evidence is I was standing outside and it started to rain. That's direct evidence of rain. Circumstantial evidence of rain is I was sitting in the hotel lobby, guy came in with a soaked umbrella and he was drenched. That's circumstantial evidence that it's raining outside. In this particular case that I just described for you, there was no direct evidence, no circumstantial evidence, but there sure as heck was a charge. Took the guy 2.5 years. I won the case. But I guarantee you, that his name wasn't cleared. He was done. All these teachers who are accused, and they are convicted as soon as they are accused. when people are charged with sexual assault, sexual offenses, their names are published, pictures are published. You can't identify the complainant. Why? The theory is if you identify the complainant, the fear of being identified will deter women from reporting. Well, I want people deterred from reporting if it's a lie. If it's not a lie, if you're telling the truth, you should never be afraid, because what right-thinking person is going to think less of a true complainant, of somebody who has been sexually assaulted? You have to be the crudest, most insensitive, unthinking human being to blame that person. It's not their fault. Somebody assaulted them. That's it. But no, those names aren't published, and that encourages false complaints. Statistics come out that say only 3% of complaints are false. Where does that come from? We've heard that statistic. Am I right? Have I have the number right? Has anybody ever asked themselves, how do you get that? How do you know? There isn't one. But what they do is they complain that the acquittal rate is 35% of sexual assault allegations. Well, as far as I'm concerned, that proves that 35% are false.
Yes, I have.
Well, it's different because our institutions are invested in maintaining the myth that men are evil, violent, and insensitive. And that it's all, as I said, feminism and feminazism. But let's remember that feminism didn't pop up in a vacuum. It's not like everybody went to bed one night and the next morning there it is. It was a reaction to the absence of justice for women. It was a realization at some point that what may have been acceptable over the previous 300 years or 400 years or 1,000 years is no longer acceptable and has to be addressed. That's what feminism was about. And rightly so. That's how people's rights are protected, is through action. But it's gone horribly wrong now. Yes, sir.
This is a really interesting point that you've made, and I also talked about this. I think feminism did start off on the right foot. It was trying to give protection to women. But in the 80s, we saw the emergence of third wave feminism, and that's when things seem to have gone in a whole different direction. Right?
You're right. You also have to remember that all of these systems that are in place because of legislation and regulations, orders in council, so forth, the formal institutions of government. Otherwise, nothing happens. Who puts those together? Politicians. Politics is a business. Like the law, education, plumbing, auto mechanics, transportation, retail, you name it. The vending of ice cream. It's a business. The currency is power. The name of the game is to get elected, that's number one, and stay elected, that's number two. And I don't think I'm pushing the envelope by saying that politicians are likely to do just about anything to achieve those objectives, those two objectives. And so what happens is we sit here and get lied to every day. That's what it is. Because God forbid, if the real statistics came out, if we were to be honest about what is going on out there, the system would look very different. So somebody who is factually innocent, and I'll deal with somebody who's factually guilty as well in a moment. I don't want to be seen as avoiding that issue. Somebody who is factually innocent, as soon as he gets charged, has a real problem on his hands. That may never go away. Even if the charge is withdrawn at the first appearance, there's going to be somebody who says he got away with something. That's all there is to it. Now let's look at the factually guilty. Some guy gets into it with his wife. They argue over whether next week's paycheck should go towards the mortgage payment or a new set of golf clubs. And the next thing you know, she's bleeding and unconscious on the ground. The cops come in, they arrest him. He's factually guilty. He's hit her, and he gets arrested, charged, and prosecuted. But through the legal system, applying legal principles, he gets acquitted. She decides she doesn't want to show up. She shows up, she gives her evidence in a way that makes no sense. The accused gets acquitted. To me, as a lawyer, accused number one, who is factually innocent, and accused number two, who is factually guilty but gets acquitted, are in the exact same position. The legal process has a particular objective in mind. It's over. If you want to pursue them otherwise, do it. But until that happens, it's over. I don't want anybody getting away with beating up their relationship partner. I think if you raise your hand to another human being, there's something wrong with you. I'm sorry, but I do. Unless it's self-defense or defense of others. But if you just raise your hand to another human being because you just feel like it, and she looked at you the wrong way or he looked at you the wrong way. I tell the story of a client. I had the husband. The police charged the husband and the wife. The wife had... she had a bruise or something to her shoulder or neck. She broke my guy's arm in 2 or 3 places with a Visionware cookpot. But the police arrested both of them. There's no common sense. Nobody should be able to raise their hand to another human being, and we have to work not to eliminate it, because that's impossible. We'd have to give free lobotomies to everyone, but to manage the risk. And we certainly have to cleanse the criminal justice system of the abuse of men, the vilification of men, the demonization of men. Now, you're all here because you have an interest in the topic, but I suspect that to a lesser or greater extent, I'm preaching to the choir. So all of us can get together and agree that this is a problem and we need to work on it, and we all feel better. Great. Well, the question is, what are you going to do when you step outside the doors? Because if you don't do anything, I'll continue to collect retainers from men who are charged, rightly or wrongly, with domestic violence, and who are demonized as soon as they get charged. Scum of the earth.
So what's the point?
Hold on a second, let's hold questions to the end. What makes it hard for video editing?
Women who are charged with domestic violence are treated very differently. There's no PARS program for women. No counseling programs for women. I had a woman charged with an offense. I won't go into any details of it. But I had a woman charged with an offense which, had the accusation been by the man, or against the man, I'm sorry, he would have been jailed, held for a couple of weeks, and released on bail, so on. This woman was arrested. They had no choice but to arrest her. The physical evidence was all there. They arrested her, held her for overnight bail. They released her the next morning on bail program, she had nowhere to go. Like, she didn't have anybody to sign bail for her. If it would have been man, he would have been held until trial. But they found a way. She ends up in a shelter. I couldn't do anything. The way that the system is geared, I couldn't do anything because her first appearance was 3 weeks away. Well, guess what happened on the first appearance? They withdrew the charge. The evidence was all there. They withdrew the charge, and we signed a peace bond because there is no PAR program. I talked the Crown into it. I earned my fee on it. But there is no PAR program for women. A man would have faced an entirely different process. There's a very old, cynical joke in my business, which is it takes a lot of hard work and a lot of time to convict the guilty, but it takes real skill to convict the innocent. And that happens a lot more than you think. A lot more than you think. So, if one of the questions you're asking yourselves is, what do I do? The answer is through the political process. Because that's what's going to have to change. The people who are within the legal system and who are invested in the continuation of what has been in place for 30 or 40 years aren't going to budge, because their careers, their mortgages, their standing in the community, and their self-respect are all tied up in this process. And they're not going to do anything to damage any of that. I'm not suggesting they're bad people, but they're human beings. And they become invested in this thing and cannot take a step back. I don't want to start repeating myself and thereby bore you. So that's all I have by way of a presentation. If you have any questions, I'm happy to take them.
Questions?
What is the police protocol if the man calls 911 before the woman?
They show up. But they show up with the same mindset. Except that now they might be thinking, I wonder if the guy's trying to cover.
Do they still arrest the man?
Sure. If they think they should, they do. And their policy manuals are all designed to arrest the man before they do anything to that woman.
Is there any cases where the woman gets arrested that you know?
Sure. Of course there is. Well, I just told you about one. Sure. But it's not nearly with the same frequency, and yet statistics tell us that women get as much enjoyment out of it as men do. They initiate it as much as men do.
Hi.
Hi.
Real life case. I went to court over assault. I played back 3 messages she left on my answering machine, which, she didn't exactly not know she was being recorded, right? So she left them on my answering machine, so that was admissible. So we played it back in court, and she's essentially flipping out over wine.
Right.
Just psychotic, right? It wasn't working well for her. So she decides to tell the detective that, I don't know, something else, that I was trying to bribe her or something. I forget what it was now.
Mm-hmm.
Just garbage, right? So the detective puts it on the Crown's desk. And my lawyer's like, what are you ambushing my case? This isn't disclosure of evidence, right? Either we get an acquittal or stay of proceedings. Take your pick, right? So they pick stay of proceedings.
Right.
So I signed a peace bond.
Right.
Later in my life, I drive tractor trailer, and I got to apply for a fast card.
Mm-hmm.
And
Good luck with that.
I got one first in 2005. I actually got one. I guess it's because when you apply in Detroit, they actually know the difference between a real crime and the crap I got charged with.
No.
Well, this one did anyway. I was lucky.
No, what they do, you got lucky if you got your fast card.
Yeah.
The Americans have a very strange system that changes every 5 minutes, or seemingly. So, for example, There are two kinds of peace bond. There's a common law and a Section 810, and I've heard that they treat them differently. I'm not going to go into the actual legal differences between them, but they treat them differently. They also treat discharges differently. There are two kinds of discharges in Canada available under the code. An absolute discharge, which is the judge says, go forth and sin no more, or a conditional discharge, which is you're on probation for 12 months, keep the peace, be of good behavior, follow certain conditions, and if you do all of that, then for all intents and purposes, the discharge becomes absolute and you're free and clear for Canadian purposes. And there's no conviction in either case. It's just findings of guilt. In the States, an absolute discharge, fine. A conditional discharge, nope, full criminal record as far as they're concerned. So it's the same as if you would have been convicted.
So they look at a non-conviction as if it's a conviction.
Yes, sure. That's
Well,
the
it's-
Americans.
It's their country, they could do whatever they want.
Absolutely.
Yeah.
And they don't do that just for domestic violence. They do it for everything.
Yeah. I'm still driving tractor trailer across the border. The thing is, they need truck drivers so bad that, they can do this all they want, but
Okay.
they're either gonna slow down the flow of traffic or they're gonna let us
Yeah.
through, right?
All right.
So, I'm doing it again. But I'm wondering does that mean I'm sort of guilty somehow in some weird way as far as Canada's concerned?
No. What I do, and what most lawyers do, defense lawyers, when it comes to a peace bond, here's the process. The Crown will stand up and say, we're agreeable to resolving this by way of a peace bond. Here are the allegations, and they'll read in the allegations. Then, the accused has an option of either A, showing cause, or arguing why the peace bond shouldn't issue, or saying, I don't want to show cause. I'm not fighting it. What I say is, Your Honor, my client does not admit any of the allegations. In fact, he denies all of them, but does not wish to show cause. And that's all the court needs to hear. So it's a blind eye to the whole thing. But if anybody ever ordered, the reason I do it that way is so that should anyone ever order a transcript of that day's proceedings and Her Majesty the Queen against Jones, they will see that when confronted with the peace bond and agreeing to the peace bond, Jones's lawyer said he's not admitting anything. We're just not going to fight you over it. So no. Not as a matter of law. General opinion, I don't know.
Apparently, I was at my girlfriend's place after I was charged. There's a letter on her desk about a summons to go to court because I went to court, so she, of course, also got the summons.
Right.
And they didn't refer to it as Her Majesty the Queen. They called her Regina.
That is Her Majesty.
Yeah. I was thinking, what, the province?
It's from the Latin, Regina,
Oh,
meaning
okay.
queen.
So I thought it was her first name or something.
No,
Oh, okay.
it's Regina.
Okay. There you go.
One more question, if you don't mind. If a female makes a false allegation and it's proven in court that she's made false allegation, why are the courts not, charging her or making some consequence?
Excellent question. Thank you for that one. I meant to address it and I forgot. There is a charge under the Criminal Code of Canada called public mischief. It sounds like the way that the charge is described, public mischief, it sounds like I toilet papered somebody's house, or I toilet papered a mall, a shopping mall where the public is expected to be. No. There are a number of elements to it. One of them is leading the police on a false investigation. The starting position for a conviction on public mischief is jail. That's where they start, and it's just a matter of the number. If the complainant gives a statement under oath that turns out to be false, you can add perjury, which is lying under oath on a material point. The reason they don't prosecute is because it would deter people from reporting. It's the same reason they don't publish names. As a practical concern, it's difficult to prove that somebody made a false allegation because you're trying to prove a negative, which is hard to do. But the reality is that they don't do it because they say it'll deter reporting. It'll deter a specific kind of reporting, false reporting. And I hope that the government will agree and the police will agree that that's something we need to deter. But they just throw things out there, and the public has swallowed it whole on the altar of public safety. I don't know if that answers.
I have a question for you.
Yes.
When sometimes false allegations are made in an affidavit in family court,
Yes.
and some of these allegations are just absolutely nasty.
Right.
Once that is submitted into court, it becomes public record.
Yes.
So if somebody was to go inside the courts and access that information, it conceivably can destroy your character, even though you were never charged, just
Yes.
an allegation. My question is, what can you do to deal with that element?
There are provisions to get sealing orders, although they're very hard to get. It's unfortunately a risk that we just have to live with. And what you hope to do is that when an affidavit like that is filed, the opposing party's lawyer cross-examines on that affidavit and does it effectively and demonstrates that the affidavit is false. So that's the mechanism. So if somebody gets a hold of it and then it finds its way into into a local newspaper and the contents are published, the lawyer from the other side will say, here's a transcript. These allegations were false. Here's how I proved them to be false. Print a retraction or I'm going to sue you. That's how you do it.
And what about social media? I mean, we can go after your mainstream media. Social media
Same
is
thing.
Same thing.
Same thing. We have to give up, first of all, because your initial question, Attila, touched on the concept of privacy. We have to recalibrate our definition of privacy. The old notions are gone. You can no longer, figuratively speaking, walk around your apartment in your underwear scratching yourself. You can't do it. Social media, if your phone is on, they'll track your movements for the last 10 years. They know where you've been. You can't expect the same level of privacy. You cannot eliminate any risk associated with that. All you can do is manage it. That's it. And we have to accept that, because if we don't, we're going to drive ourselves crazy. You have to accept that there's a risk out there. That's all. And be prepared to enforce your rights.
Given the data on domestic violence indicates that majority is mutual, are you aware of any cases where assault between partners where both partners have been charged? And is that prevalent, or how many cases would you say you've seen where that happens?
I've had some.
And in those cases, would you see any where there wasn't a complainant, meaning one of the parties involved didn't actually wish to have their partner charged?
Oh, yes. But it happens in single-party charges as well. The police get called in. What happened here? ABC, they haul away the guy, and the wife says, well, where are you going? Oh, we're arresting him, ma'am, on assault of this and that. I don't want you to arrest him. I just want you to talk to him. Sorry about your luck. We're not here as social workers. We're not here as marriage counselors. We're police officers. This is our job, and we're going to do it. See you later. So sure, I've seen both ends, and it happens.
I've got a question here for you in regards to disclosure.
Sure.
I work with a number of, certainly see men and women who have been subjected to arrest, and I advocate and help for them. Now here's something that comes up quite frequently. The parties will come and they'll say they're working with their lawyer. There will be video disclosures by the person making
By the Crown.
by the allegations. There'll be video disclosure. Sometimes, maybe in child protection cases, there'll be some video from children. Their lawyers are telling them that they can't have a copy. They'll actually tell them what the law prevents them from getting a copy of their disclosures, and they can only read them in their lawyers' offices.
Correct.
That they can't take them home and in the convenience of their own home and in adequate time to properly review that.
Correct.
What are you aware of in law that actually prevents a defense lawyer from allowing their clients to, say, for instance, take a video home so they can go through it carefully to many times on their VCR or whatever to think about it? Is there an actual law that prevents that?
Yes, there absolutely is.
Okay.
I'll start with the back end of the answer. There is only one person on this planet, one, for whom I would risk my license to practice law, and she gave birth to me. Nobody else is worth that risk. I'm not going to do it. I don't care who you are. The answer is, disclosure belongs to the Crown, and they do with it as they wish. When I get video disclosure, I sign an undertaking that contains, among other things, those provisions. Sometimes there's wiggle room in the sense of being able to show video disclosure to an expert. But if my client wants to review that disclosure, I've signed an undertaking. And if I breach that undertaking, I've done two things. One, potentially obstruct justice. Two, breach the rules of professional conduct imposed by the Law Society of Upper Canada, where they can yank my ticket.
Well,
So it's a problem.
could I suggest something else then? Because it raises an interesting question. Also, as a lawyer, you have a duty, and if I recall in the Code of Ethics, that you are to fight vehemently, or I forget the word.
Yes.
Basically, as hard as you possibly
Yes.
can for your client.
Yes.
And number two, there's procedural fairness, and there's the fundamental principles of justice.
Yes.
So you can look at these disclosures in a way, for instance, people do need time. Like if they want to sit and look at disclosures for maybe 3 or 4 days, they need to sit because they work during the day and they want to have time. Could a lawyer, I can see your argument there that maybe there's some fear on your part. Could you not give the similar piece of paper, disclosure, or consent to your client, that your client would agree to take this? Like a library book, they would agree not to disclose that, and they would return it to your office. Could you not be seen as taking reasonable protections to ensure confidentiality of the Crown's materials, yet still comply to you're trying to bring the rules of fundamental justice to the parties, bring procedural fairness to their case, and because you're not really giving the parties I guess the other thing is that people who are self-represented do get to have these things. So in other words, there's an unfairness. Because they've hired a lawyer, they can't see the video except at the lawyer's office. Yet, if you're self-represented, you get to take the video home, and you do have this time.
Not necessarily. What the Crowns will do in those cases is they'll tell the accused, you want to watch the video? Come down to the Crown's office. We'll give you privacy and a computer.
Well,
Watch it all day long.
well, I would,
It interferes with work? Too bad. There's nothing we can do for you.
yeah.
Now, to answer your, because you raised an important point, the principles of fundamental justice. Those are enshrined in Section 7 of the Charter, which reads, every person has the right to life, liberty, and the security of the person, and not to deprive thereof except in accordance with the principles of fundamental justice, which is a great thing to say. But then you're left with trying to figure out what any of it means. You are further left with the following problem. Section 1 of the Charter of Rights and Freedoms says, all of the rights enshrined in this charter are subject to such reasonable limits as can be demonstrably justified in a free and democratic society, which is a somewhat long-winded way of saying that the rights are limited. They're not just carte blanche. They're limited.
And I would agree, but I guess the question could be asked is that the Crown and those people who have these disclosures also would have to reasonably explain what is the risk to themselves by allowing someone that time. If, for instance, the safety mechanism was, okay, you would get your client to sign a document saying that they're not to release it. So It's just an interesting thing we're running across, and a lot of
But
people.
my undertaking is as a lawyer, as an officer of the court. My client isn't an officer of the court. My client will sign it, take the video home, and then bring his friends over to say, hey, look what the bitch said about me. I would never do that as a lawyer. Not in 1,000 years. I gave my word to the Crown, I'm done. This is counterproductive to me, but I'm going to say it to you anyway. Not a lot of lawyers will tell you what I'm about to tell you. My worst enemy is my client. I have to protect myself against that person day and night. I don't have to protect myself against the Crown. The Crown's a lawyer like I am. They do something unethical, I've got them. It's over.
Thank you.
That answers my question. Any other questions?
And by the way, my protecting myself against my client is as beneficial to the client as it is to me. And I explain that each and every time. I don't hide it from anybody. I have them sign instructions, and I tell them it's to protect me and you, because you know where we're going. The one thing I don't want is you go home and you think, oh, this is going to happen, and then no, it's something completely different. Sorry, go ahead.
That's okay. I want to thank you for your time, because it's really fantastic to hear it, as well as the rawness and honesty with which you speak. It's very beneficial to me. But what do you propose, we can do as advocates for men? Because, I'm confronted with this, certainly, I'm talking about Australian cases, but it's pretty similar, with men who, are faced with massive injustice day in, day out. They can't afford legal representation. They're stuck in our legal aid system. If their wife or if the female has applied for legal aid, they can't get it. We need change. We need awareness, and we need something to shift. What do we do? What's
All right.
next?
It's a tough question to answer. It's a great question, but it's a hard one. And I mean no disrespect to my fellow traveler here, Brother Attila, but this movement needs to figure out how to organize. You're a train wreck. You're a laughingstock. I'm sorry, but you are. And it's because you don't know what you're doing. Look at the feminist movement. They were brilliant. Pure genius at work. They took the intellectual elite and they went in there and they got themselves organized. And I have a penchant for quoting from songs. I am woman, hear me roar. Damn straight. They may have been roaring in numbers too big to ignore, but they did it in an organized fashion. They figured out the weak points in the system, and they went at the power centers at the same time, and they were relentless. And they organized. I do not remember, I'm probably wrong, given the laws of large numbers, but I don't remember a single violent feminist protest. Yeah, they burned their bras, so what? So they burned their bras, woohoo. It's not violence. That's brilliant organization. That's optics. Get yourselves organized. You're on the right side of this. You're on the right side of it. That should mean something. But you can't get yourselves organized. You've got this group here. You've got Cafe, Justin Trottier's group. Get yourselves organized. Nobody's going to pay attention to you if you're not organized. Because there may be 100,000 of you. But if it's one of you knocking at a time, you got nothing.
I agree, Father. Thank you.
So get yourselves organized. Do it at the neighborhood level, at the grassroots level. Approach your politicians, your MPs, your city councillors, your schools.
If I were to speak to them, though, that they're too afraid.
Yeah.
They're too afraid to speak publicly. They're too afraid to
Then
have any further. They hate us with listening, and that's all it is.
Then ignore them, make them come to you. Don't go to them, make them come to you. Make it impossible for them to ignore. Helen Reddy was right. In numbers too big to ignore. If you make it a politician's currency, the way that they get in and stay in is votes. They want the X in that circle or box or whatever they're using these days. Make it so expensive for them to ignore you that they won't do it anymore. And they'll say to the feminists, okay, you have the right to equal protection under the law, but you know what? We're going to stop performing virtual castrations just because you say so. Enough. You have to make the cost prohibitive to the politician.
Yeah, if I could just add to that, something that I've done, which I've found to work very well, is I've made public deputations at the Police Services Board. And that gives me 10 minutes of speaking on the record, and I basically get deputized. It's advertised, and I speak my mind. The first time I did it, it was at it was violence against women was the focus. When I spoke about being a surviving victim of domestic violence, and I spoke about other things, the women's organizations and the women in the audience, some colleagues of mine said it back to me that they wanted to kill me because I spoke those words.
Yeah.
But if I and dozens of other men began to speak that way and addressing the committee of the whole at in your own city, then all of a sudden it's like they keep hearing it over and over again.
You can't be afraid of them. You cannot let them take control of the debate. One of the most fundamental rules about debating, competitive debating, is if you want to win, frame the question. Take ownership of the vocabulary of the debate. If you wrestle that away from them, but you have to hang in there. And you can't be gathering 3 and 5 and 12 at a time. You have to get into the hundreds and the thousands, because that's what gets you attention. You have the advantage now of social media. So you don't need to get fascist television's attention anymore, to get their multi-$1,000 cameras out there. You can show up with your little video cam with your phone, videotape your own thing, and publicize it and publish it. They'll pick up on it if you develop inertia, if you develop momentum, and by the way, do it respectfully, always respectfully. Because if you demand respect, you have to give it.
You have to be diplomatic.
Yeah, it's not only the right thing to do, the golden rule and all that, but it's the practical thing to do. They want to start yelling and screaming their heads off. I had a television appearance a couple of years ago, and I was up against this guy who was representing the so-called victims' rights groups, survivors of male sexual abuse, hockey players, that sort of deal. And there was some legislation that was being proposed, and I said very calmly on the television channel, I said, you know, all of these things that these so-called victims are saying, they're the product of anger. They're just angry. And there's really nothing more to it than that. And we cannot give in to their anger. We cannot let their anger dictate what we want to do. And I said it in this tone of voice. I did it, A, because as I said, I thought it was the right thing to do, but also, B, I knew it would get to him. And it got to him, it was like moths to the light. He was screaming for 1.5 minutes. And I didn't say a word. And he finished, and the host said, well, Lawrence, final word's yours. And I said, well, if that's not anger, I don't know what is. And that was the end of it.
The anger is injustice. You know, I think when I see victims displaying anger and in many forms, I don't necessarily condemn it because they're angry because they're not being heard. They're angry because they've been wrong.
Agreed, but not in the legal system. Don't come to me in the criminal justice system. Get away from me. You have no rights in that playground. You got nothing, and I have nothing for you. You want to go get counseling. You want to get support. I'll be in there before you, supporting that effort. I will be there for you. You want to confront the person who did this to you in a justice circle? I'll be there for you. I'll tell my guy to do this, but not in the criminal justice system, which is a blood sport. It is the presumption of innocence and the protection of liberty. And I will not have it ruled by the anger. Because what these people who advocate for victims' rights groups, they say, well, we're not being heard, and we should have a say, and we should determine that. I have one question. Let's set it aside for the criminal justice system. Person A is driving their car, slams into B's car from behind. B is hurt, broken leg, limping for the rest of his life. How much say does B have in his compensation? None. Not an ounce. All he can do is bring evidence forward and say, this is my damage, let the court decide. That's it. He doesn't get to say what the payment or punishment is going to be. And I don't think it's any different for the criminal justice system.
I think we're pretty wrapped up.
All right. Thank you so much for listening. Appreciate it. We will see you.
We will see you.
All right.
Thank you.
So this will conclude the 2015 Domestic Violence Symposium. I wanted to thank all of the presenters for taking a lot of time out, some that have traveled from far away. I also would like to thank Christian, our sound man, and Sean, our videographer. They've been lugging equipment around and make sure everything sounded right and taped correctly. I would like to announce that I will be speaking with many different people that want to get involved so that we can map out a strategy that will work. We do need to get organized, as Lawrence had mentioned, and to make sure that we're firing on all cylinders. I'm going to be laying out a 10-year plan to deal with this issue, because I don't think that we're going to get too far in 1, 2, 3, 4, even 5 years. And I also want to let the public know that I, anyways, am 100% committed long-term to ensure that we get to our politicians, that we get to our lawmakers, that we get to the lawyers, the judges, our police forces, social workers, medical people. This really is where the focus needs to be, because what I really would have liked to have seen is that we have an audience of these people, not us who know exactly or pretty well what's going on. We are the converted. We know what's going on. What we need to do is to engage other people. And I've heard different folks, a daughter would say, I don't care about this. But the moment that she has a son and there's an incident, then all of a sudden it becomes important. So we need to find ways of getting our message out and connecting with the general public, but more so to also connect with the people who officiate over us, who we entrust. They're supposed to keep the Queen's peace, but oftentimes a police officer will make an arrest that shouldn't happen. So that is the focus that I would like to take, and there's a lot of work that is to be done ahead of us. Thank you very much.